Right, good afternoon, everybody. I think we'll make a start. There are a few people still joining. And it feels very strange to be sitting in my study at home, speaking to the computer, knowing that there are lots of people out there who I hope can hear me, but I can't hear you. This talk's going to be relevant to whatever type of PI work you do, because when you're assessing damages for fatal claims, the same principles apply, whether the cause of death is a road traffic accident, an accident at work, or clinical negligence. It's a big topic, and I'm not going to be able to cover it in full in 45 minutes. However, what I've noticed is that when I do a fatals claim, the same issues crop up again and again, and I often have to look them up to find the answer just to make sure I'm remembering it correctly. We're going to look at all of those issues, and in the handout, which you'll be emailed tomorrow, you'll find much more detail and all the various authorities. So if you file that away somewhere on your computer, you should have all the answers to hand. I'm going to talk for about 45 minutes. And if I don't finish, I'll stop at 45 minutes anyway. Please feel free to submit questions at any time during the talk. And the way you do that is click on the question and answer button, which depending on what device you're using, will be somewhere on your screen if you move the cursor or your finger around. At the end of the talk, I'll do my best to answer the questions that have been received, and we'll get going. There are two sorts of claim that you need to worry about. Those on behalf of the estate and those on behalf of the deceased dependents. And they're both very different. I'm going to start by dealing with the claim on behalf of the estate. I'll deal with that briefly because it doesn't arise all the time. If you're dealing, for instance, in a road traffic accident where the claimant is, or rather the deceased dies immediately, there's unlikely to be any claim on behalf of the estate. But if there's a gap between the the injury and the death, and that does crop up a lot in clinical negligence cases, then there can be a claim on behalf of the estate. And essentially, it's an ordinary personal injury claim because you're going to claim all the normal sort of damages that you claim in PI, general damages, pain, suffering, loss of immunity. There's a very useful section now in the Judicial College guidelines, which provides a range of figures for death following injury, depending on the length of time that has elapsed. And then, of course, there might be loss of earnings during that period, care and assistance during that period, and medical expenses. The only additional expense that you can claim on behalf of the estate is funeral expenses. And we'll come to those in a bit more detail when we look at the Fatal Accidents Act claim. Who can bring that sort of claim? Well, the dependents can't bring it as dependents. Only an executor or administrator can bring it. And so if there is no will, then somebody needs to obtain letters of administration on behalf of the estate in order to bring the claim. And that might be the case, we'll see, for a Fatal Accidents Act claim as well. So that's claims on behalf of the estate. Let's move on to claims on behalf of the dependents, which is what we're really interested in. We're all used to the idea in tort claims of the concept of damages flowing from the breach, and whatever is reasonably foreseeable loss caused by the tortious action of the defendant can be claimed. That's not how it works in Fatal Accident Act claims. These damages are a creature of statute, and so only losses falling within the statutory definition can be claimed. And that often leads to misunderstanding of things being claimed that shouldn't be. But we'll look at what can be claimed and what can't be in due course. Again, let's deal with who can bring the claim. Here, the executor or administrator can bring the claim. But if they haven't brought a claim, or if there is no executor or administrator, then anybody who is a dependent within the meaning of the Act can bring the claim. Only one claim is brought. You can't have multiple claims by multiple dependents. So if there is if there are competing dependents, sometimes that arises where you've got a situation of a family breakdown. Then essentially it's the first one to bring the claim will be the claimant in the case. But clearly that claimant has to bring a claim on behalf of all the dependents who wish to be considered. So I'll start with the obvious question, who is a dependent? Well, there's a very lengthy and complex definition in section 1(3) of the Act. And essentially it means any spouses and civil partners, cohabiting partners, and we'll come back to them in a moment because that's not straightforward, and anyone who's treated as a child or parent by the deceased. So it would appear, looking at that wide definition, that virtually everybody is covered, but in fact, it's not. Say you've got two people who've lived together as friends for years and years, and one is dependent on the other financially. If they are not cohabiting partners, then there's no claim as a dependent simply because of the financial support. Let's move on to cohabiting partners. What do you need to qualify? Well, it's not too complicated. You need to have been living together. Well, that's pretty obvious. In the same household for at least 2 years and as husband and wife. So that rules out two friends living together. There's a very useful case on this that you'll find on the handout, Kotke and Safarani from 2005. It explains all the things that need to be taken into consideration. And just because there have been brief periods of separation doesn't mean that you're no longer living together as husband and wife. So let's move on to what can be claimed in a claim under the Fatal Accidents Act. Essentially, there are 3 categories of damages, all of which you'll be familiar with: bereavement damages, funeral expenses, and loss of dependency. Bereavement damage is a rather odd thing because it's attempting to put a financial value on the loss of a loved one. I say loved one because I suppose not everybody is in love with their husband or wife. And the level of damages we'll see in a moment has always been ridiculously low. And it's always rather embarrassing to have to explain to a claimant what they're going to get for bereavement. But there we go. Not everybody can claim it. The only people who can claim it are surviving spouses, and that includes civil partners, and the parents of a deceased child, but the child has to be 18, under 18 at the date of death. And if the child was illegitimate, only the mother can claim it. Lot of controversy over unmarried but cohabiting partners, because obviously there are many couples in the UK who've been together for 20 or 30 years, regard themselves as husband and wife, even though they've never formally married. Until very recently, they were excluded from claiming bereavement damages until a case came forward Court of Appeal in 2017 called Smith and Lancashire Teaching Hospitals. And the Court of Appeal declared in that case that the exclusion of unmarried cohabiting partners was incompatible with Article 8 of the European Convention on Human Rights. So since 2017, the UK government has been in breach of the Human Rights Act because they haven't changed the law until Wednesday last week, from the 6th of October last week, but only in respect of deaths occurring after that date, unmarried partners will be able to claim bereavement damages, provided they fulfill the cohabiting partner definition for dependents. Where there are 2 people entitled to claim bereavement damages, they don't each get award, it's divided equally between them. In terms of what you get, it's, as I said a moment ago, it's not a lot. This table will be on the handout that comes out. For deaths on or after the 1st of May this year, it's now up to £15,120, which does seem a paltry sum. And as I often had cause to comment in conferences, it's much cheaper to kill somebody in an accident than it is to injure them badly. Funeral expenses. Now, this is one of the things I'm always having to look up, because we all seem to have a row in these cases about what can and can't be claimed. No doubt about it, funeral expenses is going to cover the cost of a funeral service, and therefore most of what's in the undertaker's bill is going to be covered. What about a headstone, a memorial? Well, there's a useful, the answer is sometimes you can claim it, but not always. The cost of a headstone has generally been allowed where the cost is reasonable, but different judges take different views of this. And a recent example of that is a case called Grant and Secretary of State for Transport from 2017. The claimant put in a claim for a cost of a headstone for £4,867. The judge thought that was too much and reduced it to £1,200. Memorials in principle are not allowed, but again, if you find a sympathetic judge, he might let you have a memorial bench or a plaque to put up somewhere. So I think from a claimant point of view, it's always worth putting it in. From a defendant point of view, it's always worth contesting it. Far more controversial is the cost of a funeral reception or wake. And this is really where the law is out of step with what most people would think. There's a case called Gamble and Wilson, which actually went to the House of Lords, but on completely different issues, that was decided in 1979 by somebody called Mr. Bennett Heitner QC, sitting as a Deputy High Court Judge. And he ruled that funeral expenses did not include the cost of a wake. And over the last 41 years, it's been a lottery whether you get these damages or not. Some judges will give them, and some judges will not. What's really curious is there's never been a higher court decision on it. Gamble, as I say, went to the House of Lords, but on other issues. There's been no Court of Appeal ruling on it, and no House of Lords ruling on it in those 41 years. There have been some recent cases that seem to suggest that you can't get the cost of a funeral reception. Quite a well-known case that we'll come back to later is Noah with a K, and the Ministry of Justice, where Mr. Justice Bean was cited Gamble and disallowed the cost of a funeral reception. And it's funny how many other High Court judges have jumped on the bandwagon, because a couple of years later, in a case called Mosson Spousal, Mr. Justice Garnham disallowed the cost of a funeral reception, citing Noah. And then a year later after that, there was a case called Grant. Martin Chamberlain QC, sitting as a deputy, disallowed the cost of a funeral reception, citing Gamble, Mosson, and Noah. So what I would say about this, and perhaps those who act for defendants may disagree vehemently with this, but at virtually every funeral in the UK today, some sort of level of refreshments are provided, ranging from a cup of tea to a full meal. And I think most lay people would be astonished to discover the law, or at least some judges, didn't regard the cost of those refreshments as part of the funeral expenses. So what I would say to claimants is, given the absence of any higher court authority, it's open to any first instance judge to redefine funeral expenses in a more appropriate way. And for claimants, I would always say include them. But again, for defendants, why not dispute them? Because you've got authority on your side. There's one little outlier of a case called Brown and Hamid, and ignoring the wording of the Fatal Accidents Act, the judge in that case didn't allow funeral expenses at all, because the injury was a 12-month acceleration of death. And the judge felt, well, if the deceased was going to die anyway in 12 months, those costs would have been incurred anyway, and there's no loss. I think that is probably a wrong decision, but there we go, useful for defendants. Probate fees. Again, they're often claimed and they're frequently agreed by defendants, but they shouldn't be. In Mosson, court specifically ruled that there was no basis on which a such a claim could be read into the words funeral expenses. I suppose logically they are a disbursement for the purpose of bringing the claim, and so it could be claimed on that basis as costs. So the big part of the Fatal Accidents Act claim is loss of dependency. Loss of dependency, there's financial dependency, so money that you would have received from the deceased. There's loss of the deceased services, and controversially, there may or may not be a claim for loss of personal attention. We'll come back to that one. The statute uses rather unusual wording. It says, in the action, such damages may be awarded as are proportion to the injury resulting from the death to the dependents respectively. There's no statutory definition of injury, but what the claimant needs to prove in all of these cases is a reasonable expectation of a pecuniary benefit from the deceased and a benefit that arises from that dependent family relationship that would have carried on but for the deceased death. Essentially, benefit can mean a lot of things, but for our purposes, it's going to mean dependency on income, and income here can mean everything under the sun. It can mean earnings, it can mean pension, it can mean state benefits, it can mean promotion of career advancement, could mean fringe benefits such as private health insurance and a car that come with the deceased jobs, could mean dependency on gifts, wedding presents, Christmas presents, contributions to a house. And it's even been argued that it can include the avoidance of inheritance tax, which might have occurred had the deceased lived. So income can mean anything. Loss of services, well, those are the ordinary things that we often think about in terms of an injured claimant in personal injury case. The domestic assistance that the deceased would have provided, the personal care they would have provided, the child care they would have provided, gardening, DIY, all of that. And then final aspect is this loss of personal attention that we'll come back to in a moment. I'll skip over that one. Let's talk about what the approach is in practice. In theory, in a fatal claim, there's no reason why you shouldn't try and identify exactly what the deceased would have spent on each dependent. And there's an interesting case called AB and KL from last year, where that sort of argument was pursued. And it's probably useful to do it where the deceased separated from the husband and wife, and essentially there isn't a definite entitlement to the deceased's income necessarily, but what the deceased would have done, it may be claimed, is spend money on things like school uniforms, school trips, university expenses, driving tuition, ad hoc payments towards clothing and other expenses, presents, holidays, contributions towards the purchase of the first home, contributions towards the wedding costs for each child. All of those were allowed in this case, AB and KL. In contrast, another fairly recent case, CC and TD 2018, His Honour Judge Friedman didn't like any of those sort of things and thought all of these gifts and contributions towards wedding costs were too speculative and disallowed them all. So clearly there's a huge range of possible outcomes if you get to trial in any of these cases. One important point to make at this point is business relationships are not dependency, and consequently they're excluded. So a good example of that is a very old case from 1955, Burgess and the Florence Nightingale Hospital. A husband and wife were a successful dance act. She died, and he claimed loss of earnings for what they would have earned had the dance act continued. Those were disallowed because that was a business operation and not ordinary dependency. And another thing that will not be allowed is criminal activities. So if the deceased was a burglar, his income from that will not be allowed. However, if he failed to pay his tax, that will be allowed, but once the calculation of the tax he should have paid has been taken off. So in theory, you can approach it like that, but in practice, there are some rules of thumb where you've got a fairly ordinary situation. So just looking at the slide I've put up, where you've got a deceased sole earner leaving a widow or widower but no children, the rule of thumb is, and there's a little bit of logic to this 2/3 rule, it's assumed that a married man will spend 1/3 of his income on himself, 1/3 on his wife, and 1/3 for their joint benefit. So the surviving wife or the surviving husband can claim 2/3 of that net income. And that will be the annual multiplicand, on which you apply a multiplier that we'll look at in a moment. If there are children, it's adapted because it's assumed that the deceased would have spent a quarter on himself, a quarter on his wife, a quarter on his children, and a quarter for the joint benefit. So the multiplicand is 3/4 while the children are dependent and 2/3 thereafter. Often you can get into rows about how long dependency continues, because obviously if it's clear that the children would have left home and started working at the age of 18, then that's when their dependency would continue. But equally, if it's clear that the children would have gone to university and remained financially dependent on their parents until the age of 22, 23, or whatever, dependency can continue much longer. What about if both the deceased and the spouse, the surviving spouse, are earning? Well, now there's a rather complicated calculation from a case called Cohabiting Partners. And what you do is you add together the both incomes. You then apply the 2/3 or 3/4 we looked at a moment ago, and then you deduct the surviving spouse's income, so as because logically they still have that or still could have it, and that's how you get your multiplicand. That recent case I was looking at could produce some unfairness because let me give you an example. Let's assume that the deceased income was very small, say £5,000 a year, one of a wife doing a part-time job just to get a bit of pocket money, and the surviving spouse's income was £40,000 a year. Now, clearly the £40,000 a year surviving spouse was the main breadwinner there. But to say that the earnings of the deceased for £5,000 a year would have made no difference at all to the overall household income seems rather unfair, because it's likely that some of that £5,000 would have been spent on the family. But if you use the Coward and Comax calculation, it actually produces a negative figure. So I think that's probably worth arguing if you're in a situation like that. Let's move on to services now. Where a deceased has died, you're going to need to, and you're acting for the claimant, you're going to need to get quite a lot of factual evidence about exactly what they did. How many hours a week did they spend doing housework? Did they do the cooking? Did they do the washing up? Did they do the cleaning and the laundry? In some cases, you will have a spouse who did all of those things, and others you won't. If there are children, then clearly the costs of childcare, which are normally shared between parents, are going to be significant. I think generally, unless it's in everything except the smallest cases, it's probably going to be worth getting a care report to put a value on all of these things. And certainly in relation to the care of children, young children, the only option for a surviving parent may be to employ a nanny to look after the child, and that can be claimed. And what care reports are very good at doing is working out what that will be initially and how it will reduce over time as the children go older. Very hard thing to do unless you've got a lot of experience in these cases to work it out for yourself. lots of ways of approaching it, and it's going to depend on the facts of the case, but there's a case you'll find on the handout called Rapu Singh and the West Herts NHS Trust from 2016 that has some good discussion of how you should approach that. Just as a matter of principle, it's not necessary to prove that since the death, somebody has actually been employed to undertake the cleaning or the gardening or the DIY. Because obviously, financially, the surviving spouse may not be in a position to do that. But there was a specific ruling that that's not necessary in the case of Noah, Mr. Justice Bean. But he also did add that the assessment has to be realistic. Let's move on to this more controversial claim, which is, I've called it here, loss of intangible benefits. Sometimes it's called loss of personal affection or loss of personal care. And the argument runs like this. Where a husband loses his wife, he can employ somebody to cook and clean for him and a nanny to look after the children. But that's not the same as having his own wife present with him and caring for him and children full time. And therefore, some sort of additional award should be made in respect of that. And that argument first succeeded in a case called Reagan and Williamson in 1976. And since that time, there's been a little top up on fatal accident awards to reflect the fact that the commercial employment of contractors isn't really going to be the same as having your own husband or wife there. Initially, it was confined to wives who died, but more recently, awards have been made for husbands who died. They're not huge, these awards. They tend to be somewhere between £2,000 and £5,000 to the surviving spouse and for each child. But more recently, some judges have questioned whether they can make this award under the Fatal Accidents Act because it is a creature of statute. There are these definitions of what can be awarded. And in both case of Brown and Hamid, see on the slide, and Moss and the spousal, both judges ruled that there was no provision for such damages in the Act. And anyway, there was an overlap with bereavement damages and therefore refused to make any award. So that one you can argue either way, but financially, it's not going to make a massive difference. Coming on to the multiplier, just a few things to remember in respect to the multiplier. Normally, you're dealing with the length of time that the deceased would have lived. But if the deceased would have outlived their surviving spouse, then obviously it's the surviving spouse's life expectancy that's relevant. And all the normal questions about life expectancy will come into play here. So if the deceased, for instance, was a heavy smoker, or his wife, his surviving wife was a heavy smoker, there may be arguments that the normal life expectancy shouldn't apply. There used to be, until 2016, a rather strange rule that you calculated the multiplier from the date of death and then deducted the amount of time that had elapsed between death and trial from that multiplier. There was never any very clever reason for that. That's just the way it has always been done. Unfortunately, in the case of Noah and the Ministry of Defence, the Supreme Court overturned that. And now multipliers in fatal claims are just the same as multipliers in personal injury claims. You calculate the past loss to the date of trial, or the date of the schedule, and the multiplier from the date of trial for the future loss. There is some advice in the Ogden tables about what you should do to adjust the multiplier. And rather than using the multipliers for living claimants, what the Ogden tables recommend you do, and interesting enough, virtually nobody ever seems to do this, is to use the table 28 terms certain for the to get your starting multiplier, then adjust that for contingencies other than mortality in the normal way for loss of earnings claim, and then make an adjustment using some tables at E and F in the Ogden tables to make an adjustment for the chance that the deceased would not have survived to provide dependency. I have gone through that methodology myself on some occasions, but frankly, it doesn't really make a lot of difference to the final multiplier, and it's probably just as easy to use the basic multiplier as you would an ordinary personal injury action. Clearly, it's going to be in defendant's interest, though, to investigate the deceased's medical history and to seek disclosure of medical records, and where appropriate, obtain life expectancy evidence. Couple of subsidiary matters now. Again, this is something that comes from the Act, but it's not often used. There is a section in the Act that says the court must take into account that an unmarried partner has no enforceable right of support and therefore can reduce the award to take that into account. It doesn't happen very often, but there have been cases like Drew and Abassi, which again is on the handout, where the multiplier was reduced by 13%, simply on the basis that there was no guarantee that the couple might stay together and there were no enforceable rights anyway. So that's something to watch out for. And then an obvious point, if the deceased has been guilty of contributory negligence, that can be taken into account to reduce the award, just as it would be in a personal injury case, even though there's no fault, obviously, on behalf of the dependents. Let's look at some factors that aren't taken into account. Again, the prospects of the remarriage of the widow is not taken into account. This is to stop the judge looking at the widow and trying to make an assessment of are they going to marry again, and therefore are they actually going to suffer any loss, as used to be the case in some older cases. That's now ignored, and although it's not specifically been spelled out, I think the prospects of the remarriage of the widower would also be ignored. More importantly is benefits received as a result of the death, and that can cause some rather odd outcomes. So any inheritance received by the dependents is completely ignored. So for instance, in a case called Wood and Bental Simplex, the deceased was the owner of a farm, which he produced an income for him and which he used to support his family. When he died, he left the farm to his family and it continued to produce that income. But they were nevertheless able to claim the income that he would have gained from it and paid to them, even though they had the same income. So that's completely ignored, as are any pension benefits. So this is quite a common situation where a husband or wife dies. The surviving spouse will be able to carry on claiming the husband or wife's, the deceased husband or wife pension, but that's ignored. So they can claim the loss of dependency on that pension, even though they're getting the same pension now. Again, seems rather odd, but there we go. That's what the rule is. Deal very quickly now with the question of apportionment. The court will make one lump sum award for in a fatal accidents claim, and if there is a surviving wife, say, and children, then obviously that award has to be apportioned between the wife and the children. It's not done terribly scientifically. Generally, in cases where the surviving spouse will remain financially responsible for bringing up the children, the usual practice is to give the bulk of the dependency to the widow or widower and only a small amount to the children. There's a very useful table at paragraph 29.151 of Kemp that shows some examples of that. But I mean, typically, if the total award was, say, £200,000, you might give £10,000 to each of the two children and the rest of it to the widow. It's that sort of methodology. There are no hard and fast rules. But obviously, settlement of cases involving child dependence do mean you're going to have to go and get an approval hearing at which apportionment will be considered. So you need to have some arguments for what you're intending for at that time. Now, I've taken that incredibly quickly and got through it all faster than I thought. So I'm going to have a quick look to see if anybody has asked any questions. And an anonymous attendee has asked a question, which is this. I'll read that. If a husband has taken a much lower paid job, local to home, to look after his children, can he claim the difference in the loss of earnings? A case where I have claimed approach to the case, which makes a difference of over £1.5 million. The answer is no, he can't, because it's not losses that flow from the breach. It's that what you would have received from the deceased had they survived. So just taking your case very specifically, I'm assuming that what would have happened is that if the wife had not died in that case, she would have looked after the children, and the husband would have been able to carry on doing his well-paid job. So what has been lost there is the value of the wife's services, regardless of how the family arrangements have changed. So on those facts, all the surviving husband can claim is the cost of employing a nanny. And I suppose a harsh defendant might argue that in failing to employ a nanny so he could carry on with his well-paid job, he was probably failing to mitigate his loss. So that'd be a rather unattractive argument to run. So the answer to that one is no, they can't. And the damage would be much lower. So I've got another question from Amy Lee. What is the percentage of income that can be claimed where the only dependent is a child? I think in those cases, it would probably be, you wouldn't use the rule of thumb, because the child at some point, if the parent had survived, would have become financially independent. So there, I think you do need to look specifically at the benefits that that particular child would have received. Now, obviously, while the child is still under, say, 14, mostly that's going to be in terms of money spent on the child supporting them. And I suppose there's no reason why you shouldn't use during that short period the 2/3 of income, plus of course the loss of services on top of that, the cost of employing a nanny. And thereafter, look throughout the child's life at what that parent would have been able to provide. Would they, for instance, have paid the child's fees at university? Would they have supported them at university? Would they have paid contribution towards the wedding? Would they have provided a deposit on the house? All of those things can be claimed. And that's probably the sort of case where you actually want to look at what the parent, the deceased parent, would actually have done, rather than try and use one of the rules of thumb. Right, I'm pleased to say that we have no more questions, and therefore I'm going to wind things up a little bit early. Thank you all very much for attending. Tomorrow, you're going to be sent by email a copy of the slides, a copy of the handout that I've referred to, and a recording of the seminar. If you've got any questions at all, my email address is on the final slide. Please email me. I'll be very happy to try and help. Thanks very much for attending. Cheerio.